Well, good morning, everyone, and welcome to our Insider's Guide to Practice in the Commercial and Circuit Commercial Courts. This seminar has been prompted by the recently published revised versions of the Commercial Court Guide, CCG, and the Circuit Commercial Court Guide, CCCG, got my teeth in this morning, which have seen a significant evolution in terms of content and form. In terms of content, we intend to highlight the key changes that will be relevant to practice and save you, at least for now, having to read the 162 pages of the CCG and the 42 pages of the CCCG. In terms of form, the immediate point to note is that in the Circuit Commercial Court Guide, the base guide is only, in the Circuit Commercial Court, the CCG is the base guide, with only exceptions and modifications being contained in the Commercial Court Guide. This is a helpful development and should make navigation and compliance easier for practitioners. And it should always be remembered that the guides do not override the rules or practice directions, and they should always be read with CPR 58 and CPR 59. Now, as to the panel, I'm delighted first to welcome Judge Worcester, who's a former member of St. Philip's and is now, of course, the Circuit Commercial Court Judge in Birmingham. We're particularly grateful to him for giving up his time this morning in the middle of a judicial training course. Judge Worcester is, of course, giving rather than receiving the training. I also introduced Grant and Theodora Hand from St. Philip's. Mark was formerly a solicitor at Gowlings and is now regularly to be found, at least virtually, in the Circuit Commercial Court dealing with high-value litigation. Theodora covers a broad range of commercial matters with particular expertise in restrictive covenant cases. Now we've got some time at the end, I hope, for questions and answers. So please do use the Q&A function at the bottom of your screen as we go along, pop the questions in, and then hopefully we'll be able to deal with those at the end. Right, to start with, David, perhaps I could ask you to give a judge's overview of the key themes from your perspective as to these changes.
Thank you, James. Yes. Well, as you've indicated, the guide is not something that takes the place of the rules or the practice direction, but the aim is to bring what you need to know into one place. And it's what the court normally expects from the parties, the way business is to normally be done. But it's guidance and it's flexible and it's to be applied to the particular case. I think the key changes in this edition of the guide can be divided into two. Firstly, you've got changes in procedure and practice in the business and property courts generally, which have been planned and worked through. So in particular, the disclosure pilot, which you're all now no doubt familiar with, Practice Direction 51U, and of course the new simplified procedure for less complex claims, which came in November 21. So that's catered for in the new edition of the guide. The second major change in practice in the business and property courts, so in the Circuit Commercial Court, are trial witness statements, Practice Direction 57AC, and no doubt you're all grappling with how that's going to work in practice. So is the court. One of the consequences of not having a long narrative witness statement and simply limiting the witness to what that witness can actually say is that there's going to be a need, certainly prior to a lengthy trial, for some agreed narrative document to set out how all this evidence is pieced together. And it may be that we find the resurgence of the opening as a consequence of the reduction in witness statements. So that's one group of changes. The others are changes in practice that have rather been forced upon us, or at least accelerated by the pandemic over the last couple of years. And that's in particular the use of soft copy bundles, electronic bundles for really everything now. And secondly, the use of remote hearings. And I think the major points to note here is that in relation to soft copy bundles, it's for applications and it's for trials. That's the default position. There will be circumstances in which a hard copy bundle is more appropriate. For example, one matter we were talking about just before we started, if you have a witness in a trial who's not sufficiently competent with technology to be able to deal with an electronic bundle, it may be that you have to have a hard copy bundle.
David, there's always that practicality question, isn't there? Because courts are not set up with monitors in witness bundles ready to go unless you're using Opus or some kind of system like that.
That's absolutely right, and I think that the change has been driven from the top. So in the commercial court, you're more likely to have that sort of facility. In the circuit commercial court, where the cases are not as large, you're less likely to have that sort of facility. So I think it's something to raise with the court at a pre-trial review or at some point prior to the trial, and to raise with witnesses to see if they are up to speed. It may be that the problem can be resolved by having a junior member of a solicitor's firm sitting alongside them to help them navigate through the documents on screen. But I think the key thing is to think about the problem before you get to day one, and make sure that that there's a plan B if they can't deal with an electronic bundle.
Are those conversations taking place with you and your fellow judges in the other court?
Well, indeed, I'm speaking at the moment with my opposite number in Manchester to see what we can do, because I think if we can have some consistent approach across all the courts, so that the parties at least know what they're likely to have to do, that would be particularly helpful. And the other change we've all noticed, of course, is the use of remote hearings, and the guide really reflects what I think the courts have been saying for a while now, that if you've got something which is less than half a day, the default position is remote hearing, and if you've got something that's more than half a day, the default position is face-to-face and attended hearing. But again, it may be that you've got a shorter hearing that needs to be face-to-face, in which case you apply to the court, and it may be you've got an all-day hearing that can perfectly properly be done remotely, in which case you ask the court for it to be done remotely. And speaking personally, I'm quite happy to try and cater for the points that the parties raise. If they think it's better done remotely, well, I'm not going to stand in their way unless I positively think they're wrong.
David, if you, as an example, if you had 2 Birmingham solicitors, 2 Birmingham counsel, it's a half a day hearing, but they say, well, look, you could do it remotely, but we're only round the corner, we'd rather come in. Do you have a particular view on that?
Well, I think, as I say, if the parties want to do it in a particular way, I'm perfectly happy to accommodate that. There are advantages, I think, to having the people physically in the same place. Things get sorted out much more easily when you can have a chat outside court, or have a chat, really. We've all done that in court, and I think it also helps to, in some cases, to promote a rather more civil atmosphere if people actually have to sit next to each other rather than just speak over a screen. So, as I say, that's the default position. It's not written in stone. So there's those changes, but I think there's a wider agenda to the new editions of the Circuit Commercial Court Guide and the Commercial Court Guide, because, as James has indicated, the Commercial Court Guide applies unless the Circuit Commercial Court Guide makes some different provision. And of course, those different provisions are simplifying what's in the Commercial Court Guide rather than the other way around. And this, I think, reflects the desire to align court guides and the Commercial Court and the Circuit Commercial Court in particular. That's very much the policy behind what's happening with the guides, but it's also the view of the judge in charge of the Commercial Court, Mrs. Justice Cockrell. She's been very keen to come out to the regions to hear substantial cases in the Circuit Commercial Court in the regions and to provide High Court judges to try cases which need full High Court judges. So I think this is also to be seen as an indication that what's been promised there is being followed through. So I think those are the key matters. There's also some new forms for the beginning to start cases, which apply particularly in what are called the regional circuit commercial courts. But I think that's just because somebody doesn't understand what a circuit is. But they're there. Please have a look at those. And there's some new specimen directions for CCMCs. There are a lot of different versions around. Please use the one that's in the appendix to the new guide. That's at least as a starting point, and I hope that will simplify agreeing directions. There is also an intention to provide a standard set of directions for CMCs in the shorter trial scheme, so that you've got the same starting point for your discussions. So I think that's a very quick run through the key themes of the new guide.
David, that's really helpful. Thank you. Now, we'll obviously have a range of people on the seminar, some very experienced litigators in the commercial courts, others maybe less so. Maybe a question, Theodora, well, when do you go to the commercial court? When do you go to the London Circuit Commercial Court? When do you go to the more regional circuit commercial courts? What guidance does the guide provide us in relation to that?
Well, the guide really refers back and relies on the CPR. And like many things, the CPR is where you can find a lot of these answers. So looking at the commercial court deals with commercial claims as defined by CPR 58.1, and these include disputes arising out of the transaction of trade and commerce. And CPR 58.1 does list quite an extensive list of cases, but the general themes of those are buying and selling commodities, banking and financial services, the export and import of goods. And CPR 58.4 states that a commercial claim may be started in the commercial list. Now, CPR 59.1 states that a claim may only be started in the circuit commercial court if it relates to a commercial or business matter in a broad sense and is not required to proceed in another specialist list of the business or property courts. So when to use the circuit commercial court: if a commercial court hearing is more suitable for a hearing outside of London, then the commercial court will aim to achieve that on circuit. At B1.1 of the circuit commercial court guide, it again lists out the disputes which are appropriate for the circuit commercial court. And then it states that effectively other factors, including value, factual, technical, or legal expertise that arise, are relevant factors. Turning to when to use the London Commercial Court, at the Commercial Court Guide at B13.5 states that not all cases are suitable for the commercial court. In particular, all international road, sea and air carriage claims not suitable for commencement in the commercial court by reason of their financial value and or nature of the factual, technical or legal issues that arise should be commenced in the London Circuit Commercial Court. And it's current practice of the London Circuit Commercial Court to transfer claims subject to party representations with a financial value of less than 500,000. But James, in your experience, how fixed is that 500,000?
Yes, the guide suggests if it's below 500,000, it shouldn't be in the High Court at all and should go to the County Court in London. But in my experience, that's quite often not the case. I've got a case which is worth less than that, but involves some quite technical franchising issues. And that actually started in the Commercial Court and is happily continuing in the London Circuit Commercial Court. I think, just thinking about the regions, I think if you're less than 100,000 on average, you probably shouldn't be in the High Court at all. But I dare say, David, you've got experience of cases even below that level, perhaps where you've got restrictive covenants or some kind of injunction element.
Yes, sometimes, or where the case has a particularly has a point of law in it. The other thing I'd say is that for cases in the low 100,000s, certainly in the regions, if you've got a case that will fit into the shorter trial scheme, that's quite a useful halfway house, because you get the specialist judge, but you keep the costs down by avoiding the disclosure pilot, by avoiding cost budgeting. You've got to be able to say that you can do the claim at trial in 4 days, and that it doesn't have a lot of documents and a lot of witnesses, because you wouldn't be able to do it in 4 days otherwise. And you get stuck with a timetable. But I think that's always worth bearing in mind if you've got something in that range between 100 and 500,000. There's no limits on it, but I think that's probably a very useful thing to have in mind when you're deciding where to go and how to do it.
That's really helpful. Thank you for that, Theodora. Right, Mark, you've been sitting patiently. I think you were going to talk to us about statements of case and related matters.
Yes, much to everyone's delight, I'm sure. So section C of both guides is the one that deals with statements of case. And I wanted to pick out 3 themes that emerge, I think, from those sections. The first theme is that statements of case must be short. So not only is brevity the soul of wit, but it's also essential when it comes to pleading your case. So C1.1a of the Commercial Court Guide says that statements of case must be as concise as possible. And this, of course, is not a new principle, but it is one, I think, that's worth recalling and re-emphasizing. Because I think we've probably all seen pleadings that suffer from exuberant verbosity.
Never yours, Mark, never yours.
So, yeah, it's always my opponent's, of course. Then C1.2 of the Commercial Guide goes on to prescribe a page limit. So generally, statements of case should not exceed 25 pages, and it must never exceed 40 pages without the court's permission. And that's actually a slight increase in headroom from the previous version, where the threshold for an application for permission was 25 pages. But it's important to remember that the limits are smaller in the Circuit Commercial Court, where the recommendation is 20 pages and the threshold for an application is 30 pages. And as I hope Judge Worcester won't mind me quoting him, when we were discussing before this seminar that this page limit, he pointed out that if you can't say it in 30 pages, you probably haven't got a case. And I think there's probably a lot of truth in that.
It's probably best not to quote me on that in the Court of Appeal, but
we are attributed, certainly. There's another, I think, subtle but important, possibly important difference in the new guides on this point as well, which is that previously the Commercial Court Guide said that when you're making an application for permission to file a longer statement of case, you were supposed to attach a draft of the statement of case. Both guides, interestingly, now expressly say that you are not to attach a draft to an application for permission. You do need to specify the number of pages that you're going to need, which of course is quite difficult to do before you've drafted it. But you've got to give the court an idea. And this may simply be a sensible attempt to save costs in the event that permission is denied. But one wonders if it might also perhaps reflect a slightly higher hurdle of difficulty for getting permission at all, particularly given the increased headroom now that we have of 40 pages or 30 in the Circuit Commercial Court. Time will tell. The Commercial Court Guide also says that permission for a longer pleading will only be given exceptionally and only where good reason can be shown. And it points out that the mere fact that the case is complex or is of high value is not sufficient on its own to be a good reason. Finally, on this theme of brevity, it's worth noting that subparagraph M of C 1.1 says, as before, that substantial quotations from a document, such as a contract, should be set out in a schedule rather than being quoted within the body of the statement of case itself. And again, I think it's worth recalling this because perhaps it's fair to say that this may not be always religiously observed at the moment. The second theme that I think stands out is that statements of case should plead only factual particulars and they should not be pleading evidence. And so subparagraph E of C 1.1 says you must set out only those factual allegations that are necessary to establish your cause of action or your point of defense or reply. So only what the guide describes as primary allegations. And the wording that follows that in subparagraph E is new. And what it says is a general factual narrative is neither required nor helpful, and indeed is likely to contravene the other requirements of the section. Now, it seems to me this might reflect the provision that's new in J 6.5 of the Commercial Court Guide, and the judge mentioned this earlier on, for parties to consider before trial agreeing a detailed chronological narrative document. And that document, it seems to me, perhaps stands in place of the sort of factual storytelling that we used to get from witness statements, and of course is no longer permitted.
My issue with that is twofold. One is one has tried to agree chronologies with opponents in the past, and you get there in the end, but it's a slow process. And that case summaries, one tries to agree that either become interesting documents, but controversial, or sort of uninteresting and rather dull documents if you do it by committee. It's really going to be really hard to strike the balance on that, I think.
Well, I think that's right. And I mean, it's not mandated. The guide says you should consider it and whether it's appropriate. And it does give some urging that the parties should seek to cooperate and take a non-tendentious approach to it all. But I mean, it's certainly going to be an issue, certainly in the early days. And the reality is, of course, that advocates are used to, in their skeletons in particular, framing their case, stating the facts, but in perhaps spinning it slightly in such a way as to, present them in the most favourable light for your client, and that's presumably going to be more difficult, if not impossible, in that document. And it may be, as Judge Worcester said earlier on, it may be that the replacement for that going forward is going to be openings. All openings at trial might become more of a thing than they are at the moment. And again, I suppose time will tell how that plays out. The third, before I move on to the third one, that there's an important qualification, of course, to that general principle about how you plead facts, which is that subparagraph H of 1.3, it is still the case that if you're relying upon elements of the factual matrix, in particular for construction of a contract, for example, it is still essential to set out those elements of the factual matrix in your statement of case. And then the third and final theme I wanted to pick out on statements of case was this emphasis, which I think is fairly new, on identifying at an early stage the key issues in the case and the evidence that you need on those key issues, and indeed getting formal advice where appropriate, perhaps from the trial advocate on that point. So we see now in C 6.1, it says that as soon as statements of case have been exchanged, the parties should begin to identify, whether by formal advice or otherwise, the significant matters that are in dispute on the pleaded case. And that is obviously to inform the list of common ground and issues, and of course the list of issues for disclosure. And then section E.5 goes into a lot of detail on that point and on the need for the parties to consider at all stages how it's going to prove its case, and not to wait until trial to think about that. And it indicates that it may be appropriate for there to be formal advice and consultation on that with the trial advocate. and that should in particular inform the approach to disclosure. And again, I suppose it's all part of trying to avoid the kitchen sink approach and sort of focusing on what actually is important in the case. And E5.3 confirms that there will be allowance made in the cost budgets for that advice where it's appropriate. But it's worth noting that there's a slight dialing down or a different emphasis in the Circuit Commercial Court Guide. Paragraph E2.2 of the Circuit Guide says that that sort of ongoing formal advice from the advocate will only be appropriate in certain cases when it's proportionate to the value or complexity. And of course, the reality is, most people's cost budgets, I find, tend to have an allowance in them for, and quite sensibly, we would say, of course, for counsel's input on disclosure and witness statements and so on. And that will presumably include advice on these sorts of issues to some degree. So those are the themes that I think stick out to me from the new guides on a statement of case. And in short, what I think they come down to is encouraging brevity and encouraging a laser-like focus early on what are the key issues in the case, rather than getting distracted by the sort of peripheral clutter that can too often take up too much time and cost.
And so, counsel have their own style. Solicitors have a responsibility, I guess, to, if they receive a lengthy draft from counsel, obviously not from St. Philip's, which doesn't comply with the rules, to say, well, actually, this isn't concise, you're quoting from too many documents. I don't think this is the right approach for the commercial court, which could be an interesting conversation.
Indeed.
Right, I'm going to very briefly just deal with some new provisions as to proof of foreign law. Particularly in the commercial court, many cases involve elements of foreign law, which is to be proved as a matter of fact by evidence. Now, in the past, the general approach has been you've got to prove by expert evidence. And that obviously has a significant cost element. But on the back of the guidance of the Supreme Court in FS Cairo, there's a new provision H3 of the Commercial Court Guide, which provides for a very flexible approach, effectively a menu of options, which is consistent with the approach to other things such as disclosure. So the top of the list, as you might expect, is the full expert report, meetings and oral evidence. But the bottom is a recognition the court may take judicial notice or accept the agreement as to the agreement of the parties as to sources of foreign law, and then for the advocate simply to make submissions on the basis of those sources of law. So it might be a statute, for example, or on the basis of a established textbook in a particular jurisdiction. That's going to be particularly the case if it's a common law jurisdiction, which the court is broadly familiar. And there are a range of alternatives in between. And part of the option, may be noted, is if the parties have retained foreign lawyers to help them in relation to the other jurisdiction, they may use those own lawyers to provide the expert evidence rather than getting in new experts, which I think will be of particular interest. The actual decision the court will make, not surprisingly, will depend on a range of factors, depending on the extent to which foreign law is in issue, the importance to the case, the costs, and of course, whether there's any English decision already on that point of foreign law. And I would suggest that these provisions are essential reading in any case which involves a foreign law element, and particularly ahead of the CCMC, because that is something the judge is going to be very interested in discussing. So on that basis, I can move hopefully seamlessly to back to David to deal with case management in the Circuit Commercial Court.
Yes, well, I'll take this relatively briefly because I know we're short of time, but this is dealt with in section D of the guides. In the Circuit Commercial Court, the advantage you have is that the designated judge does the case management. So you get one judge all the way through. That's certainly how it should work. And in my experience, it usually does. The guide sets out when you apply for a costs and case management conference. It's effectively 7 days after the close of pleadings. Claimant does that. If the claimant doesn't do it, then another party can do it. And if nobody does it, the court can fix a hearing of its own initiative. You've got to be conscious of how long ahead you need to have the hearing. If you're in the disclosure pilot, then you've got the best part of 2 months to comply with that. So you're probably looking at a date about 3 months after you apply for it. to get the work done. You've also got to do the cost budgeting and complete a case management information sheet. There's a new draft of that at Appendix A of the Circuit Commercial Court Guide. That comes in 7 days before. And that deals, amongst other things, with the shorter trial scheme, which I mentioned earlier. The bundle for the CCMC, look please at the practice direction for part 59 at paragraph 7.7, but also at paragraph D5 of the new Circuit Commercial Court Guide. That'll tell you what to put in that bundle, which of course is electronic. My experience is the most often trod parts of the bundle relate to areas of dispute on the disclosure review document and cost budgeting. And as is inevitably the case, those are always in a very small font and produced at 90 degrees to the way they come up on the screen. So could you just think about the people who are reading the bundle when you put the bundle together, and make sure that those documents in particular are the right way up and in big enough print for someone in their 60s to read. A long skeleton is unlikely to be necessary. Really what I want to know at a CCMC when I'm prepping it is what areas are still in dispute. So a skeleton the day before is absolutely fine. Indeed, sometimes the later you leave it, the longer, the more you know about what's agreed and what's actually in dispute. And if it's all agreed, then the practice direction makes provision for submitting a consent order not less than 7 days before. If it's not all agreed, it's very helpful if you can have one set of draft directions setting out the directions that are agreed, and usually the vast majority are, and then the competing versions of the directions that are not. It's much easier to have one document for everybody to work from.
Just on the topic of bundles for CMCs and also generally, it seems to me still remarkably common and a really good way of getting the judge's backup, I'd have thought, which is still done, is to have the physical page numbers not match the electronic page numbers. And it's remarkable how often still that happens, and it's such an easy thing to get right, isn't it?
That's very true. Usually what happens is that you have a bundle which is numbered from the first document, and then somebody puts an index on the front. So you've got something in hard copy which has numbering from page 1 of the documents. But then the electronic version, of course, has the numbering from the first page of the index. So you're always 3 or 4 pages out. But yeah, try and get the page numbers the same if it's hard and soft copy.
Good, thank you, David. Right, Theodora, I think you're going to deal with some miscellaneous points in relation to applications and hearings.
Yes, I am. So the first point, which I think is important to cover, is the maximum hearing times, and those have been laid out in the Commercial Court Guide at F5.5. I'm not going to list them all out, but I do recommend referring to it to check what those times are. But for example, you've got application to challenge jurisdictional service, maximum time limit is 4 hours for that. You've got hearing to settle and approve disclosure review documents, half a day for that. Application for security of costs, you've got 1 hour for that. And that is, of course, subject to permission being granted. Now, if you want a longer listing time, then you need to make an application in writing specifying the additional time required and giving the reasons why it is required. The written application, it may be by letter and where possible should be agreed, should be filed on CE file as an application to a judge, and then sent, of course, to the other advocates for the other parties at the same time as it is filed. I don't know, Your Honour, what the success rate is in applying to have hearings extended from the default position.
Well, we'll see. It's not something that I've got personal experience of at the moment, but if you've got a good reason for needing longer, then by all means. But it's, I think, to everybody's advantage to try and get these cases done as quickly as possible. So you'd have to have a good reason.
And that takes me on to, and it has been briefly covered, remote hearings. The County Court Guide does provide some guidance on this. As it's been said, half a day likely to be remote, above that in person. Where it's by telephone hearings, and this is Practice Direction 23A 6.1 to 6.11, telephone hearings are going to be listed for allocation hearings, listing hearings, interim applications, case management conferences, pre-trial review, with a time estimate of no more than 1 hour. So it will be listed by telephone unless an application is without notice, one party is unrepresented, or more than 4 parties wish to make representations at the hearing, which must be eminently sensible, because I can't imagine 4 parties all contributing over the phone at the same time is particularly streamlined or efficient. You can, of course, request that a hearing is not by telephone, but you must do at least 7 days before the hearing by letter. Practice Direction 23A7 refers to video conferencing facilities and says where the parties to a matter wish to use video conferencing facilities and those facilities are available in the relevant court, they should apply to the master or district judge for directions. So we've also got the Commercial Court Guide at F.3, which details in respect of remote hearings the limitations. And if you want something other than the status quo, you have to apply. There's also a I wouldn't say it's a document, but it's a resource online called Remote Hearing Guidance to help with the business and property courts. And that lays out the same thing. And it says that while the mode of hearing is ultimately a judicial decision, the default position for all hearings under half a day will be for such hearings to take place remotely. The court will consider a live hearing in such cases only if there is a particular reason why an in-person hearing is more appropriate. Such hearings include the Chancery Division's Applications Court, the Commercial Court and Technological and Construction Court's Friday applications list, adjudication enforcement in the Technology and Construction Court. So the approach in relation to longer application hearings and trials will be a matter for a decision by a judge on the facts of each case. Those measures are in place, it says, until further notice. Now, one final point that I want to cover is the use of junior advocates. And we were just discussing before you all joined us that there does seem to be quite a strong emphasis in the Commercial Court Guide in particular about the use of junior advocates. And the use of junior advocates is said to be appropriate and should be used. And we've got a D7.1 of the Commercial Court Guide that on many case management issues, so it doesn't say all case management issues, but many case management issues, junior advocates within a team may be well placed to assist the courts. And then it goes on to say parties should consider in every case whether attendance by the more or most senior advocates instructing the case is reasonably required, and B, whether even where that is the position, at least some of the matters arising may appropriately be dealt with by the more or most junior advocates. At E1.4, on disclosure issues, the guide says that those are a good example of issues on which it may be appropriate and helpful for the argument to be prepared and undertaken by a junior advocate. At J 8.7, it says where a party is represented by more than one advocate at trial, the advocates may share the oral advocacy, although the court's permission is required for more than one advocate for a party to cross-examine the same witness. The court encourages oral advocacy to be undertaken by junior advocates. And J 13.3, it may be appropriate for oral argument about costs or other consequential matters to be undertaken by a junior advocate. So there really is an emphasis on using juniors. I don't know if the sole purpose is to put James out of a job, but it does seem to be that the commercial court guide is encouraging the use of junior advocates where appropriate. And so I think that a degree of thought and engagement with where it is appropriate to use junior advocates rather than senior advocates does need to be given in line with that guidance.
David, I'm sure you wouldn't wish to pass any comment as to whether juniors are much better at dealing with case management matters than silks. Anyway, Mark, in the time available, do you want to give us a minute or so on the negotiated dispute resolution provisions?
Yes, it looked like the judge was about to pass a comment, actually, but I know he didn't let him, James.
That was good advocacy, I think.
Yeah. Yes, I mean, at first glance of section G of the commercial court guide, you could be forgiven for thinking that there was an entirely new concept being introduced. What is negotiated dispute resolution? In reality, it's essentially a rebranding of ADR. It's not really a change in substance, I don't think, but it does represent perhaps a bit of a change in tone. And so what, in particular, the word alternative is dropped. I think to emphasize the fact that the courts don't regard mediation or indeed other negotiated dispute resolution.
Oh, I think we've lost Mark. David, can you hear me?
I can hear you. Yes, I think Mark's just frozen.
We've lost Mark. Well, he was just, as you say, dealing with the new provisions, or what seems to be new provisions. My take of those is, Mark, sorry, we'd lost your feed.
Or at least should be a normal feature is to the courts.
Mark, I'm afraid we lost you for a bit there.
Sorry about that. Am I back now?
You are back. I think you want to give us the 20-second summary, because then we'll be out of time.
Yes. So short version is change in word from alternative to negotiated. It's a shift in tone. It's normal. It's not an alternative thing. So the courts will expect it. And then the other aspect is ENE, early neutral evaluation, is, I think, going to be pushed increasingly by the courts, and I think, in my experience, can be useful for the right sort of case. Some cases I don't think it is right for. If it's a case, for example, on a narrow point of law, you might want to go straight to summary judgment instead. If it's got detailed findings of facts, it's unlikely that ENE is going to be of great assistance. But if it's a case, for example, where there are one or two key issues that can really narrow the case or indeed determine the case, then ENE can be really useful. Tactically, it can also be useful, I suppose, if you're convinced you've got a strong case and your opponent doesn't get it, then it can be quite nice. It can be hard for them to keep their head in the sand when it's a judge telling them they're going to lose. Of course, there's always the possibility that you'll find out the party with the head in its sand is actually you. But if that's the case, it's perhaps best to find that out sooner rather than later. So it's a shift in tone rather than substance. The courts expect mediation and other forms of dispute resolution to be explored, and ENE is a tool in that armory.
Good, thank you. Well, there's quite a lot of questions that could arise out of that, but we're coming towards the end of our time. I haven't actually had any questions from the floor, but David, I think you were mentioning there's going to be a court users meeting fairly shortly where people can ask questions and talk about these other things.
Indeed, the guide says that there should be 2 court users meetings a year, and what I'm planning to do is to have one shortly before or shortly after Easter, and then a second in around October time. So the first one will be, the date will be sent out to those who are on the list of court users, but we'll try and advertise it through the Law Society and the MCCBA as well. So if you've got any questions about the practice, particularly in Birmingham, then that's potentially a good opportunity for you to ask them. And if you want to send those questions in ahead of time, I can group them together and try and cover those matters in any opening statement.
Right, good. Well, David, we'll let you go off and train some judges. Thank you very much for your time this morning and your insight. That's been very useful. And thank you both, Mark and Theodora. And thank you to everyone who's joined us today, and hope to see you soon in person. Goodbye.
Good morning.